If you just found out that you might be responsible for handling someone's estate in New Hanover County, the first thing to know is that you likely have more than one option, and picking the right one can save you some time, some stress, and likely some money. My name is Ryan Smith. I'm a licensed realtor and certified probate expert. Every day I work alongside families navigating probate and estate administration throughout North Carolina. I'm not an attorney, so this isn't legal advice. What I'm sharing is educational, and it's based on my experience of working with families through these same situations. I highly recommend meeting with an attorney that specializes in probate and estate administration. If you need a recommendation for an attorney, please let me know. I'd be happy to share a couple of great options with you. So how do you know which path is best for your specific situation? It really comes down to three primary questions. Question one is there a will or not? Question two is roughly how much personal property is in the estate. So this doesn't include real estate. We're talking about things like bank accounts, vehicles, personal belongings, things like that. And then question three, is a surviving spouse the only heir? These are basically the same three questions that the clerk of court is going to ask you. So let's walk through each one of these questions so you can get a better understanding of what might be your best option. Let's start with the smallest option first. So option number one is a scenario in which there is a valid will, but you don't need to open a full estate yet. You can simply record the will with the clerk of court. In this situation, there's no probate, there's no administrator appointed, it's just the will on file. The cost for this is $1 for the first page and 25 cents for each page after that. Option two is if there's less than $5,000 in liquid assets and the funeral bill is already paid in full and the amount that you're collecting won't exceed what was paid for the funeral, you may qualify for something called administration by clerk. And this option costs $20 to file. Now, option three is application for probate without qualification. And this is for when a will needs to be legally recognized by a court, but nobody's being appointed to actively manage anything. This is $30, and there's no other filings required after this. So thus far, we have three options, and none of these require full administration. Now let's talk about the small estate affidavit. This one has a waiting period. You have to wait at least 30 days after the date of death. And it applies when the total value of personal property minus any liens, encumbrances, and the spousal allowance is $20,000 or less, or $30,000 if a surviving spouse is the sole heir and the one collecting. Once it's filed, you have 90 days to close it out with a final accounting. Please keep in mind these numbers have moved before under state law, so always confirm these costs and these numbers with the clerk's office before making any big decisions. If you are a surviving spouse and you're the sole heir or the only person named in the will, there's one more option you can consider, and that's called a summary administration. This is an option that allows you to collect and distribute the property without full formal administration. There is a trade-off for this particular situation. By choosing this option, you personally take on the decedent's debts up to the value of what you receive from the estate. So that's obviously worth thinking through carefully before you file. And if none of these shortcuts fits your particular situation, full administration is always available, no matter the size of the estate. If there is a will, you'll file as an executor. If there isn't a will, you'll file to become an administrator, and you'll need a family history affidavit. Either way, the cost is the same. It's $120 plus 40 cents for every $100 of personal property with a $15 minimum. And keep in mind, full administration comes with ongoing responsibilities. I cover this in a lot more detail in other videos, but there's notice to creditors and inventory within 3 months, final accounting within a year, and a lot of other small steps and responsibilities necessary to fulfill your fiduciary duty to the estate. This is typically the path for larger, more complex estates, and it's the one most people think of when they hear the word probate. Now, a question I get all the time is, can I just do all of this online? And the answer is partially yes. Where I am here in Hanover County, North Carolina, we have been on the state's e-court system since early 2025. So e-filing is available. There's an online portal with a tool within that portal called Guide and File that can help you through the process. There's even something on the site that helps you prepare documents. Even with these online options, the original will still generally has to physically reach the clerk. And an oath, the part where you swear to handle the estates faithfully, that still has to happen in person or in front of a notary. So online filing can support the process. It just doesn't replace all of the in-person steps yet. Make sure you bring a certified copy of the death certificate. Bring the original will if one exists, and depending on the path you choose, bring proof of what things in the estate are worth. One thing to know, and you'll hear this several times, the clerk staff is there to help you, and it seems to make sense that you would want to ask their opinion about your specific situation, but just know by law they can't give you legal advice and they can't fill out the forms for you. They can tell you which form applies once they know your situation. They can help you understand various steps of the process, but just know that they're not trying to be difficult. They just have to be very careful to not cross that line of offering anything that might be considered legal advice. So if you leave the clerk's office and you're still confused or you're uncertain as to what your next steps are at any time in the process, this is exactly the kind of thing I help families work through here in New Hanover, Brunswick, Pender, and the surrounding counties here in southeastern North Carolina. And if you're like a lot of the people I help and you're managing this from out of state and the estate is here in southeastern North Carolina, I can help you handle everything here locally. Figuring out which path applies to you before you walk into the courthouse can save you time, money, and definitely some stress. So a quick recap. Ask yourself 3 questions. Is there a will? How much is the personal property worth? And is there a surviving spouse? And are they the only heir? From there, you might qualify for a $20 filing, a $30 filing. You might need full administration. And yes, you can start some of this online, but the courthouse is probably still going to be part of the equation. Thanks for watching. If you'd like to talk through your specific situation, I offer a free consultation. There's no pressure, no obligation, so feel free to reach out anytime.